Hafa day, everyone. Welcome to the Guam Congress Building. The Committee on Health, Land, Justice, and Culture is now called to order. I'm Therese, the chairperson of the committee. I'd like to welcome Senator Roy Kinata with us today. Thank you, Senator. Today's Tuesday, February 27, 2024. The time is about 2:10 p.m. In compliance with the open government law, notice was published in the Guam Daily Post and posted to the Government of Guam Public Notice Portal on Tuesday, February 20th and February 23rd. Notices were also sent by email to senators and all main media broadcasting outlets, and this hearing is being live streamed on the Guam Legislature's YouTube channel. There are 3 bills on our agenda for the 2 p.m. hearing. These are all relative to the CHAMORRO Land Trust. Bill number 245-37 COR, introduced by myself, Therese M. Terlaje, is an act to amend Section 6A-107 of Chapter 6A of Title 18 Guam Administrative Rules and Regs, relative to the switching of application types of the CHAMORRO Land Trust leases. Bill number 246-37 COR, also introduced by myself, Therese M. Terlaje, is an act to amend Section 6A-117 of Chapter 6A, Title 18 Guam Administrative Rules and Regs, relative to the lease award of the CHAMORRO Land Trust leases. And Bill number 247-37 COR, introduced by Therese M. Terlaje, it's an act to amend Section 6A-118 of Chapter 6A, Title 18 Guam Administrative Rules and Regs, relative to the approval of leases of the CHAMORRO Land Trust. So on the first item, I've decided I'm going to take these bills out of order. We're going to start with Bill 246. All right, I think it deals with one topic that we can dispose of, and then the other 2 bills might get a little bit complex. All right. In order to, I think, understand these bills, we have to begin with just a little bit of the history, at least, of some of these things. On December 28, 2022, the CHAMORRO Land Trust adopted Resolution 2022-005 to, quote, consider additional authority requested through amending Public Law 2338, also known as the Paul J. Berdalia Rules and Regs. Although the resolution cites 21 GCA 75A103, which authorizes the CLTC to adopt rules, regulations, and policies in accordance with the Administrative Adjudication Law, or the AAA, the CLTC did not adopt rules and regs pursuant to that, and has requested the assistance of the legislature to make amendments to their rules through the legislative process with the intention to, quote, resolve many issues preventing the CLTC from moving forward, unquote. On February 2nd, the acting administrative director sent a request to my office providing for specific amendments stating, quote, throughout the years, the CLTC has been overwhelmed with many concerns and questionable actions regarding the issuance of residential and agricultural leases. The letter goes on further to state, quote, unfortunately, the controversial approval of applicants switching dates and times and transferring of applications rights by a living applicant was deemed null and void by the Attorney General, unquote. Additionally, the acting administrative director at that time noted that after further review of current leases, CLT discovered more concerns and questionable actions that needed resolution, although these concerns were not documented in the letter. In 2018, the Attorney General, well, I'm going to go even further back. In 2018, the awarding of Barragata Heights public land leases drew negative public attention to the CLTC because of the $1 a year leases in that area were awarded to government officials and certain Department of Land Management employees or their relatives, according to files and media coverage of the incident. Additionally, the leases were not issued according to the date and time applications were received. The Attorney General opened an investigation into the leases and subsequently issued an opinion in May 2018 that stated, quote, there is no authority that allows an applicant during his lifetime to transfer or switch places with another applicant. A lease in violation of this prohibition is null and void and is not subject to the Commission's power to correct or remedy. Applicants should be permitted to resume their prior sequential status subject to the order of the date and time they applied. The AG advised the Commission to review every lease to conform to ethics and government standards. Internal conflicts of interest were identified and proven should be corrected immediately to restore public trust and confidence in the integrity of the Chamorro Land Trust program and for the protection of Chamorro homelands for all. The CLTC did conduct an extensive review, and its findings were made and documented in resolutions 2018-10, 2018-08, and 2018-10. In December 2022, the Chamorro Land Trust adopted, again, the resolution I read earlier, asking for changes to rules and regs as well. That's resolution 2022-005. In between this time, there had been attempts, so the Chamorro Land Trust had gone in and ratified $2,877 leases that the Attorney General at the time had deemed to be voidable because they were not approved by the board. They were approved by directors or deputy directors. So the CLTC, the commission at that time went in and ratified 2,877 leases. They wanted to ratify as well 100 leases that were void, null and void, according to the Attorney General, but they were told that they did not have that authority to do that and that they would require legislative action to approve what was deemed to be null and void leases. So then so this was studied in great detail. Analysis was done and it was laid out. But before any action, I think, could be taken, then we got involved in a lawsuit. The Chamorro Land Trust Commission was sued, and that went on for a couple years at least. We settled the lawsuit. Part of the settlement required the Guam legislature to change the law. So we did that. We had to change the Chamorro Land Trust law. And in order to make the rules then consistent with the new law, we had to do another bill again to change the rules. So all of this, of course, has taken some time. And we're getting back now to what do we do with some of these leases. So some of these recommendations, I believe, that are in front of us today were made by the Chamorro Land Trust to rectify some of the issues that they are facing with current leases or applicants, and also to address going forward, so that we had a consistent policy going forward. I am not sure, I'm not convinced myself, whether the language in each of these proposed bills is what's really needed to remedy the situation or the best course of action, but I decided we need to have a very open conversation about this, and because this had been recommended by the former acting director, I wanted to make sure that everybody was on the same page with talking about it. We've had several oversight hearings on the Chamorro Land Trust Commission in this regard to cover some of these issues, but also to cover issues of what are their next steps, including which tracts of land were they going to prioritize in order to issue out residential leases. Because we had heard many news stories regarding the commercial leases and issues with commercial leases or potential commercial leases, but we kept trying to bring them back to where are your residential leases? Why are we not issuing these out? Where are your tracts of land? Where are the next 50 to 100 leases going to be placed? What is the priority? And which ones have infrastructure or don't have infrastructure? We wanted that to be very clear, and they had come in during our oversight hearings and laid those out. Plans for 4 different parcels of property or tracts of land, and which ones were likely we could get infrastructure, or how we could get infrastructure, and how they were working with GWA to get infrastructure so that we could get additional residential leases. We just recently passed a bill that clarified successors to lessees and applicants to include grandchildren and other people on the successor list. So that bill was passed by the legislation, went to the governor. So that's the status of that. All right, so particular to Bill 246, Bill 246 proposes to make amendments to the rules and regulations which would authorize the Commission to proceed to process the next applicant for a lease award if an applicant is unable to provide sufficient proof of any of the following: approved loan or financing for construction of a residence or a conditional letter of intent or the equivalent. B, contract between the applicant and a construction company for the construction of a residential dwelling. C, equivalent evidence of the applicant's intent and ability to construct a residential dwelling. Or D, equivalent evidence of the applicant's intent and ability to fulfill pre-existing requirements entered into between the other parties with respect to residential dwelling the applicant wishes to occupy. That's an amendment to 6A117. But in the current 6A115B, it says that the lessee shall occupy and commence to use the tract as his home within 1 year after the lease is made. And so that's why these exceptions are being proposed. 6A119B for agriculture leases states that the lessee shall occupy and commence to use the tract to cultivate as his farm within 1 year after the lease is made. These are in the rules. I was not able to find them in the statute itself, that is a requirement, but they were being required as part of the rules and regs. Again, Chamorro Land Trust has the authority to amend its rules and regs, but we're going to consider this bill at their request. Okay. So Bill 246. We're starting with Bill 246. Senator Barnett, I'd like to recognize Senator Chris Barnett as well. We are going to begin with Bill 246. All right, if there's any testimony on Bill 246, we have received written testimony from Chamorro Land Trust Commission. By John T. Birch, Acting Administrative Director. All right, but I see we have the chairperson of the Chamorro Land Trust Commission here, Senor David Herrero. Would you like to proceed? Okay. 246.
Buenos dias, Madam Chair, Speaker, and buenos dias, Senator Quinatas and Senator Chris Barnett. Inaanu si David Babauta Herrera, no Guahu Acting Chair gi Chamorro Land Trust Commission, za mafatuzu paguna haani ni parabe no apreba ni parabe alaba STE Bill number 246-37. My name is David Babauta Herrera, and I come before the Commission to be in favor of Bill 24637. This is an act to amend the subsection 6A117 of Chapter A, Title 18, Guam Administrative Rules and Regulations relative to the lease awards of the Chamorro Land Trust lease. What this lease basically does, this amendment will do is explains that if an applicant is unable to provide sufficient proof, as stated in subsection 6A117B, to demonstrate their qualification to occupy, commence construction, or use a residence, the Commission has the authority to proceed with processing the next applicant for the lease award, and then the Commission may consider other applicants who are able to provide the necessary proof of compliance with the lease. This new provision allows the Commission to move forward with the lease award process If an applicant fails to provide sufficient proof of their qualification, it ensures that the process continues smoothly by considering other applicants who can meet the necessary requirements. So, in the past, Madam Speaker, we understand that we have about 8,000 applicants in the books, and that we are basically stagnant in applicant number 6. So because of this problem, this is one of the remedies to resolve this issue. And that applicant applied back in 1995. So basically it's almost 30 years since we have stagnated and stopped the process in the commission. So I would like to voice that I am in favor of this 246-37 in an effort to move the process forward. Thank you, Madam Speaker.
Thank you. Thank you, Chairperson Herrera. Is there, we also have another commissioner here. Would you like to testify as well? Please proceed.
Good afternoon, Speaker. Good afternoon, Senator Roy Kinata and Chris Barnett.
Could you just make it a little louder, pull it a little closer? Thank you.
Guajo Cerro Garrido, a current member of the CLTC Board of Directors. In my own personal capacity, I stand in support of the following bills. Bills 245-37, Bill 246-37, and Bill 247-37. These bills would set up evolving guidelines to effectively implement the mandates of the Land Trust. Although the Land Trust has existed since the mid-90s, it was plagued with constraints that led to ineffective financing, leadership, and management. More time and focus should have been afforded to comprehensive planning towards its mandates. In its long history, many ill-thought-out decisions/blunders were made while operating the Land Trust. If one is to ask who is to blame for the current debacle, I would affirm that a diversity of local culture, politics, and the gimme attitude are the primary culprits for this diminished state of affairs. In the mainland, there is white privilege. In Guam, we have Chamorro privilege. Is that racist? I leave that to you to decide. Without these bills amending our mandates, there is a possibility of a few hundred leasees and their families that could be displaced and become homeless. It is important to recognize the need for continuous improvement and adaptation to current challenges in order to ensure the success of an organization like the Land Trust. By providing more autonomy and support to the Land Trust, it can better fulfill its mission and serve its stakeholders. The authorizing mandates for the CLT must evolve to meet the present-day tribulations. The bill aims to address historical constraints that have hindered the effectiveness of the Land Trust, including financial issues, leadership and management challenges, and a lack of comprehensive planning. In closing, I greatly urge this solemn body of the 37 Guam legislature to vote in solidarity with the passing of these three bills. Ultimately, the decision to support and pass these bills lies with the members of the 37 Guam legislature. It is essential for lawmakers to carefully consider the implications of this bill and work towards solutions that would benefit the community as a whole. And in closing, I would like to commend the hardworking employees of the CLTC. They work under extreme pressures and they have very limited access to the tools for them to perform. Thank you.
Commissioner Garrido. Yes, Mr. Herrera.
If I may, Madam Chair, for the record, I invited Attorney Mike Phillips to give us a clear perspective of how the Chamorro Land Trust started since back in we can say 1950, but then also a clear historical perspective of how the properties have been unjustly condemned by the administering government at that time, since 1898 to 1950, and then our challenges between 1950 with the Organic Act that added more complication to the process of on the land condemnation, which led us to the Arrendo program in 1952. Then from the Arrendo program up to the 1975 Chamorro Land Trust Commission. And then to add on to that dilemmas that we got some issues that resulted with the settlement agreement that gave credence to Public Law 35-112. So just for the record, I requested for a subject matter person to give us this perspective, to give us an overview of where we came from and where we are today, which is almost 100 some years, and then what is our vision for the next 100 to 500 years. So again, I thank you, Madam.
Jesus Masi, Chairperson, Commissioner Herrera, and I'm going to recognize Attorney Phillips. But before that, I wanted to read off something from one of the resolutions that the Chamorro Land Trust sent to us in this particular regard, related to Bill 246. So 246 is saying, if you're not ready with your documents, we are able to skip you and move to the next one and keep processing. So in the resolution back in 2018, when they did their full accounting of what happened, why were they declared voidable, because they didn't have commission action. One of their findings was the commission, since its inception, moved forward in issuing leases to those qualified despite skipping those who could not be located or had not completed the necessary steps to obtain their lease. Qualified and fully documented applicants who now hold leases issued under a system with fundamental flaws should not be penalized or faulted. So that's why they had been asking at the time that despite skipping some of the lease, they thought they were still legitimate and that they should be ratified. All right. Mr. Phillips, would you like to speak? Yes, you're recognized.
Susmasi, Madam Speaker and Chair and Senators, I've spoken with the Chair extensively regarding, not so extensively regarding these bills, but the issues. And so he asked me to be available as a resource in case questions come up or there's any interest in any portions of the history, more particularly, I think, the settlement agreement, which, and I'm not here to advocate for or against legislation, but the settlement agreement, I think most have seen has been used as a reason why things are not moving very fast. And before that, the lawsuit as a reason why things are not moving very fast. And another example would be the controversy that arose regarding the selection or those that received leases in, as the speaker referred to in 2018, the Barragod Heights issue, and how that slowed things down, and things like that. And so I don't really have too much to say unless there's a question. But I did want to mention one thing, Speaker, may or may not make a difference when you were talking about the lack of rules at one time. You may remember that at that time, under the administration of Attorney General Alicia Limtialco, their office issued a ruling. I was kind of surprised by it, but I'm not an expert in that area, and I just read it and remember it very well, and that is, an agency, as long as they're complying with the law, may operate, was their finding, without the rules and regulations, as long as they're complying with the law. And so when you mentioned one of the challenges that the Commission had at one time, I think it's important to include in the record that at least the finding of the AG is that's not a reason not to proceed. Now, if they're proceeding in a way that's inconsistent with the law, then at that time, I think it can be challenged. But, you know, I still presume that that opinion from the AG's office is correct, and until such time it's changed, it seems possibly a little bit inconsistent with subsequent opinions that have come out. You know, the general rule obviously is that if it's compliance with the law, the commission really has the authority to move forward. And so, again, not particular to any of these pieces of legislation, but I've discussed this with Chairman Dave, the concept that everything stops because we don't know what to do with applicant number 8 is like at the field house. If you have a concert or, you know, anything, 4,000 people, and there's one person that can't find her purse or her tickets, everybody, you just move in. It's not a big deal. And if there's an allegation that you need specific legislation in order to resume leases, that's troublesome, and not for the reasons of the fact that you can't move forward, but for the fact that somebody's saying that they can't do or haven't done anything in I don't know how long because of that. That's inconsistent with rulings of the Attorney General's office and the original language. And you know, I haven't reviewed the rules to see if that can actually be a stickler, but you know, if that's what it takes, I guess, to have them moving, then you know, that's a decision you folks will have to make. But I think the record really needs to be clear so that when you are making that decision, you'll know what the full picture is. And I think the concerns that have been expressed to the legislature over the years, since we argued, Madam Chair, the case in 92 or 93 to the case that we defended basically against HUD and prevailed, I believe. The questions I've been asked, you know, right now recently are almost exclusively why applicants that are clearly qualified are not being accepted. And so they're sent to Mark, they're sent everywhere. And I was part of that settlement discussion, and I'm a signatory to the settlement agreement. I know it pretty well. That's not in there. It's not needed. And if it's anybody's responsibility, with all due respect to those working hard, I'm sure it's their responsibility. And so one of the famous examples, and I think I've said it to any senator that I've discussed this with, is Sumai. And I've seen letters from people that are their ancestry is they're from Sumai. How can we not know that the entire village of Sumai was condemned? You stop right there, and you don't need to go any further. And Madam Speaker, you were at the hearing, and you may remember this part of that very heated summary judgment hearing when the judge from Hawaii said, how can you ask me to rule against the government of Guam when they've had wars, typhoons, et cetera, et cetera? How can you tell me that this is not the best program, maybe, because maybe they can't do a land restoration because they don't have the records? And that might not mean anything to anybody, but it comes back, I think, now, quite frankly, to kind of hit us in the face when we're saying, you as applicants, go out and prove it. That's the main reason the judge that day said, I'm not going to rule against the government of Guam. I'm not going to rule against the people of Guam because it's quite likely they can't prove it. And so how are they going to prove it when that's just not the way life is? They don't keep the documentation. They don't do that. Even the government, which only came into existence in 1950, even the government could not be charged responsibly with having documentation for all the land takings and anything that occurred because of everything that we've been through. Second, of course, to that was the United States acceptance, I believe, of the fact that on Guam, this concept of ownership didn't really control whether that land was valuable to you or not. And so people were basically losing their livelihoods when land was taken from their neighbor or their grandfather or their friend because they were working the land. And so I know Madam Chair, you're intimately familiar with the language there, but that's how that language was developed and was accepted by the United States. They understand that, okay, this is unique, and this actually goes back, we have proof, right? In 1936, B.J. Berdado and F.B. Leongro explained it to the Congress that it's different here. But what is most concerning for me is the fact that, we're in district court, the district court judge agrees that the huge problem you have is you're not going to have documentation, and then we turn around and we demand that of our people. It's like, well, wait a minute, I mean, you don't have to be at the case to know that that's one of the reasons we won the case, in my opinion. And second, then you turn around and you use the one fault, if you want to call it that, that resulted in the judge, at least on that day, siding with us. We're using that against our people. It just can't be. Now, I suggested back then, Madam Speaker and Senators, and I suggest again today, that there are 5 people on Guam. There's probably 500, but there are at least 5 people and I'll name one, Joe Borja, and the second one, me. And there's many that if you call us up, I can tell you whether there's a question about that area or not. I've been in the depositions. I've always believed, and I have papers that I've argued that, and correctly, that 60 to 70% of the entire island ended up in the hands of the Navy. But what I didn't know, and I have no reason to dispute, and I learned this through the 3 years I worked on this case, was that technically the United States government, the Navy, they condemned the whole island for a certain point of time. And so the reason I'm saying that is because it makes the question of whether this person's qualified or not a non-issue. If that's the case, then there's no land on Guam that wasn't condemned. Now, I didn't know that, but Joe Borja said that under oath, if my recollection's correct, during the deposition, and I was surprised by that, but I have no reason to doubt that because of his extensive background in this area, working with John Bond and since. And my point is this, that if that's correct, then there's no, I still don't believe under that definition that anybody's left out. And it took a little while for the United States to understand that, but it's important to know that we're not doing this under the radar. They settled under these terms, and they knew exactly what that line meant when it was proposed and accepted, probably contributed to, for all I remember, by the United States. And so we have such a liberal, progressive, inclusive, action-oriented settlement, move on, and yet there's no moving on. And people point to that as one of the reasons, and that's just not legitimate, nor is the fact that, you can't prove that you're an ancestor of people that either worked or farmed or owned or lived on the property. That just is a non-issue. And like I said, it's the equivalent of being at the field house with 4,000 people in line, more than enough seats in the field house for everybody, but you just don't let anybody come in. And Madam Chair, it's been 30 years in that line at the field house, and it's raining, and we're still not, we've let 8 people in. That's crazy. And so like I said, without taking a position on any of these bills, whatever it takes to have the commission go forward, I think might help. But as I've explained with Dave, I really think the burden of that really needs to be with those that are charged with that responsibility. And if they don't have the answer, like I said, I'm sure they can narrow it down to 5 people with regard to, can I call someone that might have the answer? Don't send a great-grandchild to Mark to look up. God knows, even as attorneys, we have trouble looking stuff up. So when I see those letters that they're directed to go to Mark, or their grandchildren from Sumai or Tidzan or places that we all know were taken, it makes me wonder, and I don't have the answer, why hasn't the CHAMORRO Land Trust Act been implemented? And I'll end with this. You remember, I'm sure, Madam Speaker, that when we brought this case in 92, 93, the remedy requested was a writ. It wasn't a declaratory judgment. We didn't want the court's opinion. We wanted a specific order, because in order to get that order, you had to show that it's literally non-discretionary. Just do it. And we were able to get that order. It's a writ. And that's different from an opinion or declaratory judgment. It's a writ. And a writ means you do it. And so, you know, it's baffling why even after being ordered by a court to implement, and I believe that the language is fully implement the Chamorro Land Trust Act, I don't think there's anybody with a straight face that can say it's been fully implemented. And it's a court order. I think it's a shame that we have to be ordered by our own court to implement our own law. But we were, and it's done, and it's history. But now that it's there, I would have never dreamed. I mean, you know, boy, 30 years. Whew. What does that say to all those individuals that were sleeping, as Judge Cruz put it, that were sleeping on their stomachs down in Adelup? And we all know some of the key people that are not here today anymore. You know, and those that are wondering, is there anything left for me? Any consequence for the fact that I waited 30 years? I was discussing that with the chair, and I said, man, I don't know, I don't have the answer for that, you know? The idea that, well, I'm not going to build a house anymore because I have a house, but man, I waited 30 years. You know, I don't have the answer to that, but to ignore that and to wait any further is just a grave injustice to all of us, really. If you have any questions, I'll be more than happy to try and answer. Thank you.
Thank you, Attorney Phillips. I agree with you that there should be no impediment to leasing particularly residential leases. I've been trying to push this. I think, the law is very clear. What are your eligibility requirements? And as you've described, eligibility should be determined by the commission quite easily without the need for extensive research by that family because of our history. It's the commissioners perhaps and the staff that needs to be, we just need to refresh what the history of the land is so that they have their parameters set and they can review these very quickly to me. Particularly if they're having them sign, you know, I am eligible and declare that. The rules just say that they must have documented proof that the applicant is an eligible beneficiary. And so I think we've discussed so many times ways to do that without requiring them to be their genealogist or land bond expert. But anyways, I appreciate that. So on Bill 246, we are saying, we're kind of putting in writing here what the commission has done, that if there's one hold up because they don't have whatever's needed, or they can't find them, they can't contact them, that they're able to proceed. So the only risk in doing this would be, you know, some kind of fraud, like you say you can't get a hold of them when you really didn't try, right? So I guess I'm going to ask you, Commissioner, Chairperson, how would you assure us that that is not going to happen?
Thank you, Madam Speaker. Well, the existing rules and regs of the process flowchart of how to qualify the applicants, they go through the same procedures they were doing for the past 20, 30 years. So what we're designing now is that I mentioned is that we were going to start doing the outreach program for the 8,000 applicants. And out of this, we call it the insert. So this is the project that we're working with the University of Guam, Masters of Business Administration group. So we have already did the preliminary format of getting the insert completed. And then that insert would be going out to the public. And then we're going to be receiving this information to vet the 8,000 applicants. Because right now the current process is that you go from number 6 to number 7, then
Right.
number 8, number 9, number 10. So what the past...
You could at least do it in chunks of 100, right?
Yes.
And so you're saying that this is a process that you're implementing that's going to quickly vet the next 100 and then the next 100.
Correct, yes.
And,
because
and that would resolve the issues in 246 where there's no holdup. We're vetting them all at the same time.
Correct, yeah.
All right.
Because when I got on board,
The only issue is if you have 100 tracts of land or 100 parcels to distribute, and you've vetted 100, one you can't contact, so you distribute 99.
Correct, yes.
Okay, and the next 101 might get that 100th parcel, right?
Yes, and if you...
So according to the AG's findings before, that was kind of out of line. That's what they're saying. So that's why I think the request for us to amend the rules so that everything looks like that's, consistent. So, but you believe, well, I'm sure that's your process that you're trying to implement, that you're going to ensure that that happens. Are there existing checks and balances in the trust that ensures that we're not skipping 100 applicants and going down to somebody on the bottom of the list?
Yes, when I got on board on March of 2022, I requested for a comprehensive spreadsheet or process flow chart. And I know that it was a work in progress. Now, what that comprehensive worksheet flow chart would do is that it would give us a component to do a check and balance or a quality control to make sure, to be definite, and to be sure that we're following the process and procedures. So that process flow chart is a work in progress, and I'm hoping to see that completed.
All right, and 246 is amending 6A117, and the requirements of 6A117 seem very hard to me. One is you have to show that you have an approved loan or financing for construction, that you have a contract with a construction company, you have equivalent evidence of the applicant's intent and ability to construct a residential dwelling. And have you been very strict on those requirements? I don't think those are in the statute necessarily, but these are only in the rules.
That's correct. Now, understanding the demographics of the island, we understand that our poverty level is very high. So even the average CHAMORRO Land Trust recipient that earns $100K, or take for example $200,000, may not be able to build a standard 3-bedroom home less than $400,000 today. So that criteria that we just mentioned there, again, it's similar to what Attorney Mike Phillips was saying, is that this one kind of creates another roadblock for the applicant to succeed. So you may give me the partial of property, but my income and debt ratio may not be able for me to qualify for a commercial loan or a generic loan from any lending institution. So I believe day before yesterday, you guys had a public hearing under 107-37, which is where the USDA came in and was presenting such a program that they were going to merge the agency with the Guam Housing Corporation and the CHAMORRO Land Trust with the USDA using that.
Another type of loan.
Right, yes. Right. Yeah, no, that's a combination.
All right, so what about, so I'm reading this to show that those who cannot get a loan, they can still show that they are going to build, right?
Yes.
Do you read that the same when it says equivalent evidence of applicant's intent and ability to construct a residential dwelling, that should pass, right?
Yes.
Even without a loan. All right, so currently, what happens when, aren't there still, all right, I guess I just wanted to confirm that this is just a rule. This is not a statutory requirement of the trust. And, but we are going to amend it to make it a little bit more flexible so that you can move on if they're not ready. But do you think this rule should continue to be implemented? I guess that's the subject.
Yes, but again, it's not a statute. So if I, for an example, I'm not able to get a construction loan, I believe that we can still allow the applicant to occupy the property, even if it's a module home or modular home or some other home that's not within the $200 a square foot kind of configuration. So I agree that we can still implement that particular rule.
All right. I forgot to mention that we did receive testimony from Lydia Telu. On 246, she says, I'm in full support of Bill number 246 regarding processing applicants for lease awards. This is to help with the processing applicants waiting for lease award. This will allow the applicants to keep their place in line for lease award, and the applicants who are ready to move forward in the lease award can proceed. It is simple. While today you are not ready to be awarded a lease, you still have your place in line. No one is removed, just waiting until they are ready. Mm-hmm. All right. So I'm going to ask my colleagues if they have any questions. Senator Kanata for Bill 246.
I just wanted to clarify with this proposed amendment on the bill, does this give you guys the full capacity to move forward with other names on the list?
Yes, what occurred last year is that they advertised about 5 names, and the process is that during the advertisement, they're waiting for people to respond. And if there's no response, I think out of 5, there was 1. So the other 4 would be sent a certified mail. And if that doesn't, if there is no response from that, then we continue and move on to the next group of people. But we service the one that responded.
Okay, but it doesn't stop you from going back to check if someone responds late, right? You can still go back and check on those claimants?
Yes.
Your legal counsel issues, do you still have any?
Well, we had a new counsel, Mr. Attorney Miller, and that was his first attendance in one of our commission meeting, or 2 times. So he looks very proactive. So we'll see as we progress forward with this program that we want to implement of doing an outreach for the 8,000 applicants. And for the 2,900 applicants, we're going to do it. We're going to bifurcate and use and do an outreach for both those that have leases and for those that do not have leases. For the applicants and the lessees, we want to do an outreach program to get a demographic configuration of what we have here. And we want to try to tie it in with the housing and urban development and the the USDA program that was presented during 107. So was that the USDA and the SUDA program requires this kind of demographics, understanding their income category based on the income table of the low, very low, and moderate income category. So from here, what we're going to do is the intermesh, the information that we're receiving, and then now we can categorize those that are in the moderate income, those that are in the low income, and those that are in the very low income. Then from there, we're going to apply with this grant and loan combination that's being presented by USDA. So that's one of the process that we're working on that I presented last week on our commission succession meeting, and it's work in progress, and I'm crossing my finger that we can complete it by the end of 2024. the vetting process of the 10,000 applicants.
Okay, that sounds good. But again, do you think legal counsel for the Chamorro Land Trust would it be beneficial to servicing all your applicants and ensuring that the board has consistent and continuous legal counsel, so that you don't get lost up in a mix with another legal counsel being appointed, right? We've been continuously having your meetings, and unfortunately, I think your meeting before the last, a female lawyer, I don't know her name, but I like I've said before, I do watch your hearings every now and then, and I'm just a little bit reserved on the progress. If you don't have legal counsel that is permanent, I mean, then you obviously go back to ground zero, because you need to explain the case, and then you're just going back in a circle, right? And I want to see the progress of Chamorro Land Trust, and I'm here to try to support those initiatives, right? The intent really is a good intent, and I know that we're all trying to get somewhere moving forward, and that's why I'm asking if you need legal counsel to be specified for the Chamorro Land Trust interests, so that the program has no more hiccups or impediments. If you need legal counsel, whether to proceed or not, there you go. Let's not table it to the next meeting or wait for the next person, or we'll wait until we have legal counsel present, Do you think that would be beneficial?
Yes, sir, Senator. That would be very beneficial. And if it's a need or a want, yeah, it's a need. So maybe one
Okay.
or two can do.
I also wanted to clarify, because you have the position also to provide sufficient proof, I would think that would require some notary, right? Do you have I mean, I know you're just new to the board, but do you have a notary still active at the Chamorro Land Trust? Can anyone answer that?
Yeah, negative. We have notaries that kind of piggyback on.
Okay, thank you for that information. We'll have to work on that, get someone in the office, notarize courses or something. Thank you. Thank you for your service. I know you give up a lot of your time personally to help the commission, so I really appreciate your time and your commitment. Also to you, Mr. Ogredo, I know you're a private realtor. Thank you for your service. Mr. Bradalio, thank you for your service too.
Thank you, sir.
Senator Barnett.
Senator Kanata, in regards to what you were asking, we have discussed the probability of trying to get an attorney to be at the land trust on a more permanent basis than the assistant AG or the AG affords the land trust. More like a full-time, but it's coming up in the fiscal 25 budget, so with that in mind, I hope you give it a clean shot.
Well, you definitely have my support. Obviously, we've had, like I stated in the previous hearing, I'm 27 years old. The program is just as old as I am. So, it's very important for us to kind of get this program moving forward. So if we have a lot of legal issues with all the unfortunate deceased individuals, Chamorro Land Trust is kind of like war claims now. We're trying to justify the injustice of the injustice. So again, I'm very happy that we still have some of the, the Rough Riders from the previous operation still alive to help push the agenda forward for those who are no longer with us. I see Miss Angela Santos, whose brother, worked tirelessly to ensure that the Chamorro people were given some land and to provide justice again for their wrongdoings. So again, definitely have my support for you guys to get legal counsel. I know land issues are also very important for us in the public health statistics part. That's where we're tracking a lot of family history. So it's very important for archival data, and that's why I think legal counsel needs to be provided to you guys so that we can ensure that data and the statistics for public health and records and archiving is all preserved as well. So again, thank you for your services, okay? Thank you.
Sizus Masi, Senator Kanata. Can I just check, is there Jessica Dede, would you like to present testimony on Bill 246? If so, please have a seat. And Angela Santos, Ronald Laguatnia, if you would like to present testimony on Bill 246, please have a seat. In the meantime, Senator Barnett, you're recognized.
Thank you, Madam Chair. Thank you to the chairman and also Attorney Phillips and Commissioner Garrido for the testimony. We were in committee of the whole the other day, and I asked Mr. Cruz about how many leases had been issued, and I just threw out a random year, 2018, 2019, Mr. Chair, and then he had responded, I believe there was one lease that has been issued. Can you just confirm that for the committee?
Yes, and the reason why there was just one, because of we were stuck at number 6, and that was the quandary that we have. So finally today, if this passes, that can open up the floodgate for us to move forward and start implementing the process to start bidding more than 8,000.
I think when Pika was the chairperson, Pika Farron, she had continued to issue out leases. So I think what you described earlier was actually in process where they were able to, if they could not contact somebody, move on, right? And we're just putting it down in writing, but they were actually able to do that, and they had done that.
Right, yeah. See, that would be the process of vetting the applicants. But on the other side of the equation, the properties need to be identified, where or which properties, which lot number, which tract number are vacant or are set for subdivision. So if you guys may recall, and maybe Attorney Phillips here would testify or attest that back in 1995 when we did the protest, there was a big movement to accomplish the Land for the Land Lease program. And the Land for the Land Lease program had maybe over 6,000 lots. These are lots that were sized from 929 square meters in the south to maybe 600 square meters in the north. So the question is that how do we get the applicants qualified and start getting, see this is what we want to do, is to have a comprehensive inventory of all the properties that have been subdivided, that are vacant and are occupied. And we may have some fragmented maps that would show us which properties are vacant or available. But again, back to the question that you were asking, Senator, is that how many leases have been issued. So since I was there 2 years ago, we didn't have any. But because we're stuck at number 6, so. But this bill would give us open up that floodgate.
My apologies, Senator, but yeah, I just have to interject.
No, it's okay.
There have been a transition of directors in and out of the CHAMORRO Land Trust Commission, and they're at a certain point, that's when the leases, residential leases stopped. And I don't believe it's because we're stuck. I think it was because when we keep asking them, where's your next tract of land that you're going to issue out, that's where we're stuck. That's not a lease, that's not a list problem, that's a management problem. It's a, where is the land? Is it subdivided yet? Has it been surveyed? Has it been registered? All of those things that should be like checklist management, that's what didn't happen. And of course, we can have some issues with some of the applicants, but that's not the main problem. We even had land for the landless land that was by law transferred back to CHAMORRO Land Trust, easily distributable, took forever to distribute those things. So I don't know, I'm a little bit not in agreement that we're stuck because we were stuck on number 6. If that's the case, then it's inconsistent, right? We were able to process leases, even under lawsuit, we were able to process leases. There was no impediment. It's really a matter of, do you get your surveys done? Did you get your registrations done? Have you divided and identified the property? And I've been pushing them to identify property that we can put sewer in so we can divide it up smaller so more people can get land faster. And I'm telling you, I've been land chair for at least 4 years now, and I have not seen progress in that area. Whereas I had seen maps before of these are the potential lands that we are going to do, and then all of a sudden it stopped. So those are issues that, I don't know, I want to beg your pardon, but there are some other issues regarding, not just because we were so stuck on number 6.
I agree. Now, merging with your, that map, the maps that have been subdivided, or what we call tabletop maps. So what we, at least in my opinion, what I see is that when you do a tabletop map for 100, 200, 300, 500 subdivision, and then you take that tabletop, right, and you interface it with the actual as-built configuration of the property, then you find problems, setback problems.
Yes, of course. So those,
And then it creates more havoc because
yeah.
we...
And a lot of havoc was caused by commercial leases, taking up all of the commissioners' times, and every meeting that I have seen almost, it's commercial lease after commercial lease problems instead of residential lease after residential lease. Sorry, but...
No, it's okay.
Yeah,
So-
right.
so-
Sorry, Senator Barnett,
No, go ahead.
it's your floor. Please go.
So can I merge with that, with the maps? So your 10737, I was listening and I heard about the 166. 166 lots have been, during the 2 administrations back, have been processed for rezoning. This is the property that's track number 10122, right across the Jigu Gym. So that went through the rezoning process, and then it went to Department of Land Management for requests for interest. So there were 4 companies that submitted for the interest to design, build, and finance. So what happened is that in 2022, right? See, that was just like 2 years ago. That was the, that's another logjam. So what do you do when you have 4 companies that came in and say, Chamorro Land Trust, okay, I'm interested to do your project for 166. So the session that you guys had there was the USDA that was there, Guam Housing and Chamorro Land Trust. So as I was listening into that process, at the same time, I was presenting my PowerPoint in reference relative to 166 to be revived. We wanted to put that on the table because it's a property that has been rezoned. It's a property that's flat. It's a property, right, that you have road, water, power, sewer within 10 feet. So what's the plan, right? Is to start getting that operation going, but then if we bifurcate again of the 166, which 166 applicants are going to be vetted to qualify to get into the land. So that's the work in progress, and I did present that on that succession meeting. I know it was like 5 milestones. This includes the vetting of the 8,000 and 2,900 applicants, and then interrelated with working with an MOU with the Guam Waterworks and the GPA. So it's a multifunctional, multi-moving parts that's all integrated into one. It's to get a family into lot number 1 that has water, power, sewer, and then we're going to add in another component on that, which is based on the USDA's presentation that day of most likely having a affordable home. So that's in the works. I know it's a tedious kind of process. It's lengthy. It's complicated, but it can be done. It was done in LADA. It was done in many of the other projects. And I don't see a reason why that we have 11,000 acres of property. Chamorro Land Trust has about 8,000 lessees standing by. Chamorro Land Trust has 2,900 lessees, and Guam Housing only has about 14 people that are in the Guam Housing program. How many veterans are in the Guam Housing MOU? Maybe 15, maybe 20. But out of 2,900, you have 11,000 acres, and this is your denominator. And then we burn about 900,000 a year on overhead for us to operate. So, we just have to tweak things, and I have confidence with the group, with the team, that it can proceed forward.
And so, Mr. Chair, this bill 246, this is a good tweak for you guys?
That's one of the multiple tweaks.
Nice. Yeah. I just, and just reflecting on what Attorney Phillips had talked about, and then, sitting in these land committee hearings for my first term, I think we've been very fortunate, right? And I reported on all these instances that Madam Chair was talking about in the beginning of the hearing, Barragata Heights, we had skipping in the line, we had, I think there was even a sitting senator who was embroiled in this controversy at the time, and we had people swapping places in line. We had relatives of the land trust employees somehow ending up with the prime property up there in Barragata Heights, and it was the reporting of myself at KUAM News and also Mr. Limtiaco at the Pacific Daily News that kind of blew this whole corrupt scandal. I mean, that's what it was, right? Blew it open. And then we ended up having to defend the very existence of the program in the courts. And, I thank Attorney Phillips and also, Speaker Terlaje for their hard work on that. That came at the request of the governor, I believe, right? Attorney Phillips?
Which request, Senator?
To, represent the Chamorro Land Trust.
Oh, yeah, the governor, the AG, the time sitting Senator Therese and Pika Fair in the chair.
Right, yeah. So I'd also covered those. On a side note, have you been compensated for your service to the Commission of the People of Guam?
No, we're still in court. The government won't pay my bills.
Okay, so I guess just back to the scandal at Barragata Heights, right? That was one of the issues that there were just so many things. And so the chair at the time, Chair Pika, had gone through, and then what ended up happening is they had to go through every single application, and they made all these determinations about, you weren't supposed to do that, your lease is null and void. So I guess my question would be, how is this tweak that you guys need, how is that going to affect all the leases that had previously been determined to be null and void for, whatever reason?
Okay, what this thing would do is basically to move forward from number 6 to 8,000. So that means that if we move to number 7 forward and vet the 7, we won't end up in court with tweaking this and putting it in statute.
Thank you, Mr. Chair. Yeah, and this kind of expand on what the speaker had talked about. It does seem, and I don't think this is anecdotal because I read the news every day, all the news, all the time, 7 days a week, 365 days a year, and all I ever hear about Chamorro Land Trust is like the speaker had said, these commercial leases that we're entertaining. And, I get it, the intent of entertaining these commercial leases, what I believe was to generate needed revenue for the land trust to conduct the surveys and the infrastructure and all those other things, right? Though it's confusing to me how much time we spend on these commercial leases when, and I've seen some of the commercial leases that we issued, they're getting such a great deal, right? And what ends up happening is we have these commercial entities hogging up these huge chunks of land for, pennies on the dollar, and we're not seeing the benefit to the land trust. And so I feel like this is a good tweak, like you said, and I also appreciate that Mrs. Talou, who I know is a land trust whistleblower, I appreciate that she's testified in favor of this. I'm not so sure, and I'd like to hear the testimony on the other bills, but again, I just want to reiterate, to me, the priority should be leasing out to the residential and the agriculture And I just, in my opinion, I feel like if we're going to enter into these commercial leases, then it has to be ball and knife for the land trust to generate that revenue, because, you know, obviously we're facing all these funding issues relative to surveying, infrastructure, divvying up the land, and those are all things that I think are preventing us from issuing the leases. And I mean, what is the biggest thing we're talking about? Affordable housing, right? And we all know where we are with the land, and our people, they need it. And I've spoken to so many people who applied back in 1995 who, like Attorney Phillips had said, never got a call, and then it was like, busted, they found their own way to build their own house, and then it's like, well, never mind then, you know? So, and I remember I was working at Leo Palace back in 1995, and a bunch of my coworkers had took time off. They took the day off to go wait in line, and I remember it was a long line, and I couldn't take the day off, so I never got to apply. But when I see my friends who went to apply back in 1995, almost none of them have the land that they applied for. So I just want to, after we work through all these impediments, to me the focus has to be getting land to our people so that we can live up to the intent and the spirit of what the Chamorro Land Trust is supposed to be. And I've told you again, Mr. Chair, I totally support you, and I know where your heart is. And I just hope that we can move these things that are standing in the way so that we can get the land to where it's needed, and that's to our people. Madam Chair.
Senator Barnett, may I just add a little something to what you've stated? We are a new board and we have a new manager. I believe we're very aggressive, and yes, we've been focusing on commercial because that's our money generating feed financially. You're right. It was a sweetheart deal for the occupiers of commercial lease, because like you said, they were paying pennies on the dollar. But we're being very aggressive. We've already addressed the raceway. We're addressing the golf course, and we're addressing a recycling company that has shady past. So we're trying to make corrections. You know the saying, sins of the past, the sins of the father are not carried on by the son. I hope you see us as that generation that's going to make things right. It's going to be a long, hard road because there's a lot. There's a lot out there. And I'm not in it for the money. I'm here because of my convictions. I want to help the people of Guam. I mean, I'm a government retiree, so I'm not a rich man, but I have sympathy for people who are in a lesser state in the economy than I am. And I personally want to see things go right with the land trust and with the dealings with the land trust. Thank you.
Thank you, Commissioner Garrido. And I have to say, I've read all the testimony that you provided for the committee since I began serving as a senator, and I meant no disrespect to your service to our people. And in fact, when I say that I support Chairman Herrera and the work that he's doing, that goes for all the commissioners. I understand that you guys have inherited, a whole lot of issues that you're working through. But I know you understand. We have to work through these things so that we can get that land out to the people. So thank you again for your service, Commissioner Garrido. Sizos Masi, Madam Chair.
Sizos Masi. Okay, so Jessica Dede and also Glenn E.A. had signed up. But okay, so Jessica, you may proceed.
Hafide, I'm actually going to read the testimony from the Acting Administrative Director of Chamorro Land Trust, John T. Birch.
Please, yes.
Okay. Hafide, Speaker Terlaje, I'm writing to express my support for Bill 246-37, which proposes the amendments of subsection 6A117 of Chapter 6A, Title 18, Guam Administrative Rules and Regulations. Concerning the lease awards of Chamorro Land Trust leases, I firmly believe that these proposed amendments are crucial for addressing concerns and improving the efficiency of the lease award process. However, I would like to clarify that my endorsement of this bill is my opinion and does not represent the official position of the Chamorro Land Trust Board at this time. It is important to note that the board has not formally discussed this bill. The amendment within Bill 246-37 aims to empower the Chamorro Land Trust Commission to move forward with processing applications when sufficient proof of an applicant's ability to comply with the residential lease terms is not provided. This amendment is essential to prevent delays in processing applicants who can meet the terms of the lease. While the intention behind this amendment is to streamline the process and ensure efficiency, it is important to carefully consider the legal implications and potential limitations. It is crucial to assess whether this amendment is in alignment with the existing statutes and regulations governing the Chamorro Land Trust leases. At present, I am awaiting legal guidance to ensure that the proposed amendment is legally sound and compatible with the current legislative framework. This analysis will provide valuable insight into whether the amendment can be enacted through the regulations or if amendments to the land trust enabling legislation will be required. I commend the efforts of the bill's sponsor for your unwavering commitment to improving the lives of our island's residents and families. Sizos Maasi, John T. Birch.
Sizos Maasi, Ms. Dede, for reading the testimony of Acting Administrator Birch. Appreciate that.
Thank you.
Mr. Laguatnia? (246)
Okay. 246 na ang gagawin, no? Oh, half a day, todo samsu. Saludos and half a day, Senora Gehelu, Senadora Therese Terlaje, Senador Chris Malafunction Barnett, dan Senador Roy Kinata. Si Jesus masih naman ano kamso. Senem importante na manaano kin man senador para iman taon niya gini ha representa gini kita nota. Kwa man monggi pamalo lo an ma aglihi ho sama punta para na puesto debi de onano. Amza mo na manaano apat sa corazono eno. Gaya gitu gini pa besopoti STI tres na priniponi. Za tatutunin natin STI 246. Maulika si Jessica na opio na pabiketungo mo na sinya gini si Octo Director John Birch lo ano gikatanya no na hasuporti. Enigi primera be mentia todi tres za basta zambiaya tazagwa sa gaya sa basta zambiaya sa tidaw na pabinamege lo gaya gizu gini sa bonitus din na dinanya sa gaya si talili si Celutas Mike Phillips buras ti siya man Guerrero no nasa no buras ti siya sinya manalo telefono de palabra ti Guerrero azu mafananan Tamalefo, it's the activist. Gua ha palabra activist. Gua ha loki palabras para racist. It's the racist tsat tauto. Timan tsat tauto it. It's gi zao na be. Lo be ila ozi na palabra ko mekilang niya activist. Lo sina unu Guerrero. Gini ni palabra guerra. Lo na magov na patali. Lo kay tana si Angela gini. Tana ihaga. Difunto angit sa kumpailek ko na. Dan si Bardat, si Celuta Dave gini tintingus Dave na gagi corazonnya gi mantau-tauta si Celuta loki si Earl pinapat sa mona za manita gana adzigi malagota para ta ajuda mantau-tauta senador edza na gagi hafa binabana na patana lalibiano ipara ma empatta hujung istina tonolo dinanchawa senador ta Chris dan senadora Gehelo Therese na bala zata saana banda ji commercial za bala zata fanoi hujung tono para education hagas manangano sa mga lo sa ti qualificajo loki sa utunga i qualification i permit teningo na ti debit yung gay tano ginaon mo edzigi unu na siguro na taja titalu gi education ni man mahahala gi fila na man naitano man taitano edzigi na siguro sa di malofan tempo fenomo Señor Senador non dilito di i kucinadas pafet tasangan belum magai no tadlili haji siaman mananai haji siaman afan fofona haji siaman matsatsanda bastet no pege gi kurasonta na pata ajuda iman tau-tauta sa edzigi nagai gini pabe support teachers e 246, 245 dan 247 sa timangok kwa sti siya na para o panggaigya gini manggaigya sti siya i man member commission para umana lali biano mo na po maajuda e man tau-tauta ni para o fan gaitano dan ezo na patiloki hamenti si Senador Roy Kinata pudi i abogado hinirat ni magay David yung gaha masya permanenti tagiji klasan bakonari GIAA manggay abogado sa jangin para kada 2 años para pata ilihi i abogado hinirat hatu laikaha i abogado mana minalagot niya David yung gaha uno ni posaga jo tungo todo itinutuhon niya estay finakpo niya enigi importante jawa na babimenti ano jagili ni spiritu ni Senador bodazo ni ha sonik jahana ma prebas tin na line gaigi lokin na tatati na sonik i spiritu loki si difuntu kompaleko si Angel Santos ja mismo gaiga itselunya gini gifiona sumelom suno pat kita agak mas patgun kita mas patgun pesestigi gaiga spiritu kita hagut seluta enigi nagaigi loki gini para espiritu ni mantau-tauta ni pata ajuda i mantau-tauta ufan manai tano manu ni nasinyan niasti komision por favor gaigi ju gini chalo na befan ajuda befan supporti lo enna magai pabesangan na pabesupportisti todi tres da basta jabe na fandannya todi tres dan gaigi ju loki na pabesupporti loki si celuta gena tatti si Robert Celestio agas manita gena son CHAMORRO ja por favor atendi no celuta sa untunga situasyon pago kada dai na la tempo pegagi corazon mijo jon empati ujung loki para eje siya i tresi ni manaigwi zawang ngokko loki senadora utunga na fedmiao za maulik na gaigyo gana na puesto amju na dos na magaigi wala ramon no fangaigi loki pomalo na jo mana anuk lai pomalo na senador fan anuk cukati janiju cukati lo fangaigi cukati pon sangan un palabra ni afa lo fan anuk giman tau mu sa importanti Jesus masih loki senyor na gaigyo anuk na i interesmu jani corazonmu gaigi giman tau mu at suka mandidiam lo megay maneega za megay maneekungok edza pabesangan za hutu na hamzo ni mangaigi si Jesus masih
Si Diyos masi, Senyor Laguanya. Angela Santos.
You know, sometimes I have to test the mic and my voice projection before I start. You know, I wrote this testimony thinking that I'd be here on time, but life doesn't have it your way all the time, and I was late, and I came in, I heard, and it was good because I heard, you know, Attorney Mike Phillips over there give a great, even though it wasn't anything pertaining to the bills, he just gave his take because he and you, Speaker, gave your spirit to implementing this program for our people. And that's a lot, considering what you guys had to go through and who you had to face. So, in the past few weeks, I've heard this where, you know, if you want something done, you don't ask. You just implement, you just proceed as if it's already happening. You live it already. Give an example, being independent. You don't ask to become independent. You just start the process. You start producing on your land and whatever else that you feel that is the livelihood of independence for our island, no, and our people. And when you start to write laws, you don't ask whether, you don't ask, I mean, you do your research, of course. But in this sense, Speaker, you were part of the process. So I'm sure that your research has been thorough, right? And thank you for that. I just wanted to start off with that. And Spencer Zup, buenas and off a day, honorable senators in attendance. Gual si Angela Santos, sign a ma'asi to the committee and the chairperson who put forward this public hearing for these three bills. Bills on 245, 246, and 247-37 core are what I'd like to speak upon. I would like to ask that my testimony be submitted in support of all three bills. In my tenure as a commission member, we had faced many blockages that held us back from awarding applicants a lease, decisions we could not proceed with because of the law that states there can be no switching of application types. That was a big hindrance for us, which just stalled the processes for many things. These issues alone were time-consuming and restricting to take any type of action for our constituents. As they are separate bills addressing separate disparities within the rules governing the CHAMORRO Land Trust Program, I believe that they serve one main goal. That is to assist the CHAMORRO Land Trust Commission with the decisions that hinder movement in the processing of from the last time I was aware, over 12,000 applicants in line. Our people, most of whom have been waiting since 1995, and to not deter or discourage future applicants. I just recently had somebody today ask me, Chalu, can we still apply for CHAMORRO Land Trust? I was like, every day, let's go. As well as addressing pressing concerns within with our constituency, currently in the process of whatever their positions may be in this life, and since we've had that major storm last year, which left many of them homeless. This eases the decision-making process within the commission by clearing the way in order to address more concerns, more pressing concerns. We've had that discussion many times throughout this, just one bill of 246. Although I asked whether I could have this testimony be the testimony for all three bills, I'd also like to ask if I could input just a couple of other things on the Bill 245. Talu to the committee and the hard workers who place their time in researching, listening to the issues of our constituents, and the Land Trust Commission in amending the GAR section of the law to have forward movement in our land restorative program for our people. I rise in support of all three bills pertaining to our CHAMORRO Land Trust Program being heard today. Who agradeciam to todo, dyan sa na maasi.
This is Masi. Angela Santos. All right. Is there any questions for this panel on 246? Senator Caneta. Senator Burnett. All right. Chairperson Carrera.
Reference to this amendment, I understand that I think we were trying to get a opinion from the Attorney General, or so. And may I ask the attorney if he can see if this bill is applicable to our statute? I mean, this amendment?
If I may, Madam Speaker, as an attorney, and I think the senators know, you have the right to amend your laws. The legislature created the CHAMORRO Land Trust, and it's as simple as that. So if someone's saying they're asking an attorney whether or not the legislature has the authority to amend their statute, I don't know if they're going to get an answer because it's a no-brainer. The answer is absolutely. It's your statute. And so if you're amending, whether they're your rules and regulations that passed, and it's your statute, so I don't think anybody needs an official legal opinion because it's a no-brainer. The answer is yes, you have the authority to do it.
Madam Chair, if I may. Is your wait list available online? Is the published wait list available online?
I know I have the, on the 8,000 you're saying, the 8,000?
Correct.
I do have the database, but I'm not sure if it's open for the public. I'm not sure if the server is, or that's posted, and maybe we can ask our staff here.
Ms. Day, can you answer that or no? No worries, if not, it's fine. I just wanted to clarify if we can get that data online so that people who are not, we're circulating public notice, obviously through newspaper channel because that's the governmental position, right, is that the mass circulation is through print media. But obviously we're in the 21st century. A lot of people have shifted to the digital world and digital age. I know a lot of us are certainly not too comfortable with that. We still have a little bit reservations with it. But I think we've also kind of failed if we're only putting on the paper trail agenda. We need to put it on the digital media so that people who are not on island for whatever reason and still have a land lease, obviously, they need to be aware of the situation. And probably they don't even know that their name was published, a year or 2 years ago, especially with COVID being posted. A lot of us weren't in the business of even moving from our own residences in that time. So I think it's kind of a dated post, and I think we need to update that. If you guys can have it updated on the website, I will write a letter to the director to try to get that master copy. At least the name and contact information be privately, or what do you call it, redacted. But try to put as much information as possible, but try to protect the privacy of the individual as much as possible. But just we need to get it kind of digitized so that people who are not too aware of the paper media running. That's all. Thank you.
I will pass that along to the acting administrative director. Thank you.
Thank you, Madam Chair.
Thank you, Senator. All right. There being no further testimony on Bill 246, we will move on now to 245. So Bill 245 will allow the Commission to approve an applicant's request to switch their application types from residential to agricultural and vice versa. It will allow the Commission to approve requests from applicants who wish to switch their application date and time rights to a qualified applicant in the third degree of consanguinity of the applicant if an emergency exists which makes the transfer or switch imperative. This again is a change to the rules. I am not sure that these are requirements by statute. They don't look like it. And so my question, of course, is, do we need these rules if they're not in the statute? Do we want these in the statute? And will this be applied going forward or going retroactive? And is this intended to ratify the 102 null and void leases by passing this language as opposed to expressly saying we are ratifying the 102 leases? Again, this was sent to me, request by the CHAMORRO Land Trust previous acting director. So I would like to hear your comments on it. I'll begin with the chairperson. Oh, sorry, let me just give very little background. So there were 102 leases in 2018 that were deemed null and void because they were transfers, as just as described in this section. They were called switch of time/date, not allowed under the provisions of Public Law 2338, were deemed to be null and void. So that was a determination by the Attorney General of Guam. The commission then came in and said, we want to ratify those. They found that the reasons for the switch of time and date were to assist a family member from becoming homeless, to allow a transferee to build a home when transferor was not able to due to age or illness, take advantage of veterans' benefits, intrafamilial family switches, and these were common practices allowed by the Chamorro Land Trust since 1997. So all that time, they just thought that was proper, and it wasn't until 2018 when someone told them, you can't do that, and those are all null and void. So they had asked, because of these reasons cited, that those 102 be ratified, and now we're looking at this change to the regulation. So Chairperson Herrera.
Thank you, Madam Chair. Yeah, 102 leases that are listed by the Attorney General in 2018. Well, of course, when we analyze this from the point of beginning of how, number one, first, how do you get 102 leases when we're still at number 6? That's one logic that short circuits my mental wiring.
Because they continue to process leases despite what you describe as being stuck today. They were not stuck back then. They thought it was perfectly proper to move ahead when they could not reach somebody. So they found that most of the leases that they went ahead on are also applicants. Thank you. Go ahead.
Yes, I understand. And that's the Attorney General's, I guess, memorandum of opinion in 2018. So just because I'm a new member also, every commission meeting that we have an Attorney General that's present. So then again, whose responsibility is it to say that yes, you can issue a lease even if you pass the time and date, or whose responsibility is it that you can switch applications? For the record, I cannot blame the applicant, because the applicant is basically relying on the rules and regulations based on how the administration is interpreting the language, number one. Number two, the applicant is also kind of relying on the attorney that's with the commission. And then number three, you have a commission group of members of five individuals that would take a vote. Should we issue the lease or should we not issue the lease when we know that their time and date? And then the other factor, the fourth factor, the ghost factor. Itaw-taw mo na daling pasa sa Maulika. No, pari. So these are the interrelated factors that we're faced with today, as Commissioner Earl Garrido was saying. The sins of our fathers, and the sons may try to correct the sins of the past. But if we look at the analysis from the Attorney General, we can say that there are 102 now and void or voidables. And then today, should we or should we not resolve this so we can move forward and address the 8,000 applicants and also address the 2009 lessees? So for the record, I guess your question is that, is this, 102 going to resolve the issue for those that had been issued leases, or should we not? So, thank you.
Chairperson, Commissioner Herrera. All right. Commissioner Garrido? On 245? Oh, I'm sorry. Can I get Commissioner Garrido? On Bill 245, would you like to add anything?
Well, basically, as the acting chair said, we don't really have real data to determine how these things transpired in the past. But in going forward, I personally would like to have verification from the Attorney General's office that says we are empowered to do that. Meaning, if they cut the line, then we have to remedy that based on what the rules and regulations states. And if it's not covered within the rules and regulations, that means that maybe this person has to be pulled out of the lease, and we avail that property to somebody else who's in compliance. I personally don't want to displace an applicant from land that they're already occupying, but at the same time, we do have a set of rules that we have to follow based on our mandate, and it's a very difficult situation. That's why I personally would like to see a strong opinion from the acting AG or the AG before I take it upon myself that we must remove this person because of the misdealings.
Thank you, Commissioner Garrido. Ms. Dede, are you going to testify on behalf of Acting Director Birch or on yourself, on your own behalf?
Acting Administrative Director.
Okay, please proceed.
Hafiday Speaker Terlaje, I'm writing to express my support for Bill 245-37, which proposes amendments to subsection 6A-107 of Chapter 6A, Title 18, Guam Administrative Rules and Regulations, specifically addressing the switching of application types for Chamorro land trust leases. I firmly believe that these proposed changes are vital for addressing concerns and enhancing the efficiency of the application process. However, I would like to clarify that my endorsement of this bill is my opinion and does not represent the official position of the Chamorro Land Trust Board at this time. It is important to note that the board has not formally discussed this bill. However, I would like to bring to your attention some considerations that have been raised regarding possible limitations and legal implications. It has been brought to my attention that the current statute does not provide any provisions for applicants to switch their place in the order of applications. Furthermore, it has been noted that Chapter 75 and 75A do not allow for the modification of a lease from one type to another once an individual has been granted a lease. Given this analysis, it raises doubts about the potential effectiveness of the amendments proposed in Bill 245-37 Core. It is important to recognize that the regulations alone may not be sufficient to rectify these issues without amending the existing statutes. At present, I'm awaiting legal guidance on the matter addressed in the bills to determine whether the problems can be resolved through the promulgation of regulations or the amendments of the land trusts. Enabling legislation will be necessary. I commend the efforts of the bill sponsors for their unwavering commitment to improving the lives of our island's residents and families. Sizos Maasi, John T. Birch.
Sizos Maasi, do you know how it came to his attention? Is there a discussion with the legal counsel for the commission? The questions that he says have brought to my attention, or just checking.
No, I don't.
All right. Okay, I have those same questions, but this again was introduced at the request of the Chamorro Land Trust. All right, so Attorney Phillips, would you like to talk on this matter, Bill 245?
Not unless you have a question regarding the exact same issue. Of course, the legislature has the authority to modify the rules or to change the law. Again, asking for an opinion whether or not there's any inconsistency when the body that is making that determination is the legislature is really asking the wrong question. If the land trusts were proceeding without the involvement of the legislature, then it's an interesting question, maybe. Although I think that your responses are similar to what I would give, Madam Speaker. But since this question is before the legislature, the question of asking the Attorney General what the Attorney General thinks of whether it's consistent with law or not is just misplaced. I'm
Why are they telling you?
not sure why that's repeated, but I think you as senators know, as well as anybody, you have the authority to make that decision.
Thank you. Señor Leguan, already, and Angela Santos, you testified on Bill 245 already as well?
Well, I'd like to actually chime in, Speaker, and ask if the switching of types of applications, right? There's also the opportunity for us to look into whether, because we do have those constituents who've come to the board when I was there at the commission, and they had some rare, maybe the case was they had half an acre off of what's allotted for an agricultural lot or a lease or a residential lease, right? But so if we're able to, and it states that if you have more than you're allotted, then you would have to go before the legislature, in which we're doing right now, and request to, I guess it be in the case of like a special lease, right? That's how you would word it. But in this case, we're already looking into that, and we're presenting here is the opportunity to switch leases types. So if there's an opportunity to look into, let me move this closer. There's an opportunity to look into closer to even possibly a agricultural to commercial lease, an agricultural to commercial lease, then that'll kind of nip that in the bud and offer the commission the opportunity to hear those types of cases instead of sending the lessee who's been in that parcel, already planted their house, planted their family, planted seeds, whatever the case may be. They've planted their life there already. So that lessens one movement for the lessee, or even just the commission to try to decipher where they can handle other business, right? So if there's that I could proffer is looking into agricultural to commercial, adding that into the amendment. We can talk more about it if you'd like. Thank you.
Thank you. All right, Mr. Celestial.
Alpha de Buenas, Speaker Terlaje, Senator Malafunction, and Senator Canasta. My name is Robert Namaluk Celestial, and thank you for having me speak for a little while, because I've heard a lot of requests from different chairperson, the commission members, and also a written testimony from acting manager Birch. I'm one of those issues where the original, well, I don't want to say if the original, but Mr. Joe Borja was the director at the time, and he allowed me to switch applicants with my cousin. And then find out that, yeah, I took her 1995 year and they gave me a lease, to find out that later on, after I built my house and farmed the land, that I was null and void. And then years later, with, what's her name, Pika, and the other commission, wanted to make me whole according to Attorney General Tuff. He said we wanted to make Mr. Celestial whole because my cousin passed away. And when she passed away, according to the rules, is that if no one comes in within 180 days to claim that applicant, then the board has the authority to name a successor, a beneficiary. So that's how I was able to be appointed as the next beneficiary to my cousin. And then he gave me a new lease with an addendum. And so they gave me the 2 acres that I had as agricultural lease. Then later on, I was saying, no, we got to take your lease away because you're under agricultural subsistence and then you have 2 acres. And I said, okay, but I didn't do anything wrong. I mean, I farmed the land, I have goats, ducks, chickens, and I built myself a wonderful home. And then I was threatened that they're going to take my lease away. And I said, why would you want to do that? I thought you're supposed to be helping us and supporting us because we're the ones that are able to qualify according to whatever was told to us by the commission and the chairperson at that time. And so right now I'm in limbo. And I'm in limbo because, one, they say that my lease is no good, which I think it's still valid because it was deemed by a commission, the board at that time, and with, what's her name, Pika. So I believe that my lease is valid on that point, but not valid because I have 2 acres, and according to agricultural subsistence, that you could only have like a 1/4 acre or 1/2 acre, and I have 2 acres. But that wasn't my fault. It was deemed to me by the commission, and I followed all the instructions that he told me, and here we are today. And here it says that an applicant may request a switch of application type from residential to agricultural or agriculture residential. But I don't see anything here where it says from agriculture to commercial. To remedy mine is that if you grant me from agriculture to commercial, commercial is you could have 1 to 2 acres or even more, which will make mine even more valid. And then they don't have to correct the issue anymore. So I'd like to make a recommendation on my behalf and others who are in my situation that since the legislature has the authority, not the Attorney General, to make laws and changes and so here I am today asking that if you could make an amendment or an addition to from agriculture to commercial and approve it in this bill 245, then that's why I like to make my requests known for the record. Thank you, Jesus Masi.
Jesus Masi, Mr. Celestio. Is there anyone else who'd like to testify on Bill 245? If not, I'm going to proceed with Bill 247 before I open it up for questions. All right, so Bill 247.
Madam Speaker, real quick, on 245, before you proceed to 247, are they the same or they're different bills?
They're different bills.
Okay, I just wanted to clarify something. In the case of agricultural and residential properties, I believe there's a difference in square meters, if I'm correct, Mr. Chair? So I believe an agricultural property could be anywhere from 1 to 15 acres or even more if you had the connection, I guess, right? But on a residential property, it should be only 100 by 100, give or take, correct? Can we clarify that square meterage?
Yeah, residential up to 1 acre, that was...
Okay, so I'm kind of concerned with this legislation in the sense that there might be a little bit of a hiccup.
Can we confirm? Okay, so residential, you get up to 1 acre, residential. But for agriculture subsistence, the rule says not less than 1/4 acre nor more than 1/2 acre, correct? Is that what you've been applying?
That's what's
Subsistence.
on the subsistence.
Right, so what he's citing, I think, is not subsistence, it's commercial, right? So switching from residential 1 acre to subsistence agriculture, which is up to 1/2 acre, is very different than switching from residential 1 acre to potentially up to 15 acres, right?
Correct, yeah.
All right. Yeah, so I get your point, but I think this bill did not speak about commercial, but I understand Mr. Celestio's request. Yes, Attorney Phillips.
Madam Speaker, for those that have been to Mr. Celestio's, farm, home, he's got it all. It's phenomenal. He's a model. I haven't been to every, tenant's property, but from those that I've been to, Mr. Celestial is the model that really, I think most should envy. And to force him to call his work commercial, I think would be unfair. It might be simpler just to say 2 acres for agriculture or something like that. Because my fear is then he falls into yet another category in order to meet his maximum. And so he's moved over to commercial, and the commission's given that authority. But then there might be other requirements that really he's not brought on himself, and I think it might be simpler just to allow the commission to do that. I guess it's 2 acres or something like that. It might be easier to do that.
Thank you. Senator? All right, yeah, I do have a lot of questions on Bill 245. There's like, for example, what do you mean by emergency? How are you going to apply that? And regarding these transfers, but I think if the director himself is not clear, then I'm going to have to go back to the commission and flush this out. But on 247, since you're all here real quick, before we get on to our next hearing, Bill 247 is going to, it says that the commission may award leases regardless of the date and time of application. This was an exception made by previous legislatures that allowed those who were on the land for other purposes. For example, they had been living there under a land use permit, and they had continuously been on that property since prior to 1995, I think. Let me see. Yeah, July 1995. And had consistently lived on there. So this kind of flushes out those rules and regulations, but sorry, but this one doesn't make that, I'm not clear on myself on this one. I couldn't get clarification. And so in the interest of time, I'm very sorry. I'm going to allow you to testify if you would like, otherwise, but I'm going to have to call another hearing on this bill. I think we need to clarify it with the commission itself. And I think this is actually not as high priority as the others, because this one is dealing with another type of list. This is not the 1995 list, the people who've been waiting for years and years for these things. But yes, Chairperson, please.
Well, it's a good thing that Attorney Mike Phillips is here, because the Chamorro Land Trust Commission this is like the beginning of the resolution or how to resolve the families that have had all their properties condemned under the land use permit criteria. There are 3 categories in 1952. And in 1952, under this roof, there were like 500 families that have been displaced because they were evicted out of Sumay, the entire Sumay. They were evicted out of the entire Fena property, and a lot of them were also evicted or out from the other NAS, Naval Hospital, Nimitz Hill, up to Anderson Air Force Base. So this land use permit program started in 52. So those that have been displaced, the land management at that time designed this program to accommodate these families. So this land use permit was applicable before the Chamorro Land Trust Act in 1995. So it would be logical, right, that if everybody in this room were evicted from Sumay, and then we were given a land use permit to farm, why then would it be logical that we, for an example, that's everybody in this room, be put on the side when the Chamorro Land Trust Commission started in 1975. The first group of people are still the qualified beneficiaries that were noted under the settlement agreement, the same class of people that were displaced from the unjust land taking. So the logic here of the land use permit not being addressed shall be addressed, because they were the same victims back in 1952, and they were the same victims that had their properties condemned between 1944 to 1968.
All right. Okay, so.
And we can discuss this in
Commissioner
another bill.
Herrera, I agree with you. So, but I thought that existing law already qualifies them. The existing law already allows them, even without having applied, to continue.
Correct.
My bill, however, at the request of the land trust, kind of tweaks when we can honor that.
Yes.
And that's the part that I'm talking about.
Yeah,
I don't think it's clear. For example, the Land Trust Commission had asked that we only ratify previously awarded leases if there's a house, if it had been surveyed, and then they said property that has no access. I didn't understand that part.
Most
Property
likely,
that has no infrastructure. Yeah.
Yeah, that would be the second part of the first component of Section C. But just to address Section C, I understand that the logic was saying not to amend this because the first come, first served that started in December 2nd of 1995. And I understand the other logic is that why didn't the people from the land use permit stand up and lined up in the 1995 December 2nd? The logic here is that when at that time, the law would have accommodated the people that were displaced in the very beginning.
They are accommodated, aren't they?
To remain, but not to be given the lease.
Oh.
See, there's the missing component, is that we may remain there,
Okay.
but if there's no lease, and the land use permit, the strength of a land use permit is a permit.
All right.
The lease is a lease. So
If there's a land use permit to me, and that's been going on for years, and that's an easy one, it's clear. But there are some that are getting these accommodations based on mayor's verification. That's really the questions that I had for you. Do you have any issues with the mayor's verifications? The mayor's change,
yeah,
and but they're supposed to be certifying continuous use since prior to 1995.
yeah. Well,
So that issue's been brought to me, and I just want to make, what are your thoughts on that?
you're right. Mayors are replaced, I believe, every 2 years or every 4. So for a mayor to certify that, I mean, again, like Attorney Phillips was mentioning, that if that particular family have been in that property and there was proof or that they were there, and that we can kind of research more, because if a mayor was only 30 years old and he was there, and a 30-year-old mayor was being asked, was Tunusay there, and Tunusay was born in after World War II, he may not understand who was Tunusay and where did Tunusay ranch or live. So maybe an additional, using the land use permit as a document to backtrack where Tunusay was, because the land use permit was 1950 to 1975.
All right. Okay. I'd like a little bit of additional information
Okay.
from the land trust regarding the mayor's certification. Otherwise, yeah, a land use permit, I have no objection to that.
Okay, will do. Thank you.
All right. So.
Madam Chair?
Yes.
Real quick, sorry. On the subsection C, the commission may, I would recommend that the commission shall, so that we don't have another kickback down here for them to get clarification on what they should or should not do, right? I think we've, in numerous occasions, we continue to have the word may in a lot of legislation, and it becomes a little bit of a nuisance when things are delayed because of that word may. So I would recommend to the committee that they remove may to be shall, so that it can reflect. And I also wanted to clarify the notary fee. Is that inclusive of in subsection A, there's a processing fee of $50 for the commission? Does that cover the notary fee, or is the notary letter fee separate?
I don't see the fee.
In the Section A, first page, line 15, there's an applicant shall pay a one-time fee for $50 to the commission within 30 days of application submittal. And then on the back, it says that there needs to be a letter to the commission notarized. So is that? Yes, 24537.
Sorry, I'm looking at Bill 247. My apologies. Okay. All right. All right, is there any other testimony on Bill 247? We have the acting director's testimony. Would you like to read it? What is your position, Ms. Dede?
I'm a land agent too.
Okay, please proceed.
I'm writing this to express my support for Bill 247-37 Core, which proposes amendments to subsection 6A118 of Chapter 6A, Title 18, Guam Administrative Rules and Regulations, pertaining to the approval of leases of the Chamorro Land Trust. I firmly believe that these proposed amendments are crucial for addressing concerns and improving the lease approval process. However, I would like to clarify that my endorsement of this bill is my opinion and does not represent the official position of the Chamorro Land Trust Board at this time. It is important to note that the board has not formally discussed this bill. The amendment within Bill 247-37 suggests several modifications to the existing law. It empowers the Chamorro Land Trust Commission to award leases to applicants who qualify under specific provisions, regardless of the date and time of the application. Additionally, it outlines criteria for the ratification of previously awarded leases, taking into account factors such as the existence of single-family dwellings, ongoing farming activities, survey completion, absence of access and infrastructure issues, and compliance with applicable laws. To address the problems of the past, I believe it is important for this amendment to be applied retroactively to December 2nd, 1995. By doing so, we can ensure a fair and comprehensive resolution to the past lease awards. This retroactive application will help rectify any inconsistencies or injustices that may have occurred prior to the proposed amendments. While the intention behind these amendments is to streamline the lease approval process and to ensure efficiency, it is important to carefully consider the legal implications and potential limitations. It is crucial to assess whether this amendment is in alignment with the existing statutes and regulations governing the Chamorro Land Trust leases. At present, I am awaiting legal guidance to ensure that the proposed amendment is legally sound and compatible with the current legislative framework. This analysis will provide valuable insights into whether the amendment can be enacted through regulations or if amendments to the Land Trust enabling legislature will be required. I commend the efforts of the bill's sponsor for your unwavering commitment to addressing the concerns surrounding the Chamorro Land Trust. Sizos Maasi, John T. Birch.
Sizos Maasi, Ms. Dede. There was also testimony submitted by Lydia Talu on Bill 247. It says, I also object to the additional sections of number 247. The applicants with the land use permit could have taken the time to apply for CLTC like many of those who held a land use permit. The land use permit was used to mainly for farming purposes. To build a structure on the leased lot required approval from the Department of Land Management, and how could those structures be permanent when it was a year-to-year lease? Because an applicant had a land use permit should not be a reason to jump the line of the applicants who have been waiting close to 29 years. Is there any other testimony on Bill 247? Mr. Garrido.
Earlier, I did have a conversation with Acting Director Birch on the 247. I'm in agreement with him, and my position on all three bills is I stand in support of it, but also with the caveat that this is a living mandate type of document, and it's, like I said in my earlier testimony, it's subject to evolution. as we discover new barricades that pop up in front of us, that if we can evolve, if the mandate can be evolved, then we come before the legislature to help us resolve that, remediate it, and correct it immediately.
Thank you. Attorney Phillips, are you willing to answer this question? Can we, the legislature, apply such a provision retroactively to 1995?
I believe you can, because you have the authority to ratify, in the sense, the question is this with ratification, could you have done it at that time? And of course, the answer with the legislature is yes. With the commission, I think that distinguishes your authority from their authority, for example, with the, I believe it's the 102 applicants, and that they did not have the authority at that time to do it, and so they're not able to quote-unquote ratify. But that's a different question for the legislature, because you do have the authority and did have the authority. So the concept of ratification as applied to the commission is very different from the legislature. And just one point, Madam Speaker, regarding the implications. If what Chairman DeBitt is saying is correct regarding the purpose or the reason for the use of the land outside of the lease, so they have the permits, and what he was saying dealt specifically with really land restoration. I don't know that to be true. I don't know that to be false, but assuming what his research has found is correct, that would be very consistent with the negotiated settlement, because that was the purpose, to take care of people that were displaced because of the actions of the federal government. And so I don't think that would be a problem. I don't know the answer to, I've not verified, although I have no reason to doubt what Dave has found, but if that's the reason, then I think it would be consistent with that, because if it wasn't, I'd be concerned about mixing. But if that's the reason, then that should not be a problem with the settlement agreement.
Would passing this bill and making it retroactive ratify the 102 leases from the past?
I think if for example, yes, the legislature can do that. I'm not saying that this bill does it. It's not clear to me.
Okay.
And quite frankly, that's why I suggested to Mr. Celestial that he put on the record his situation, so if the legislature goes ahead and approves that or something like that, there'll be no doubt that it was intended to rectify his situation. But as written, I can't say, Your Honor, sorry, Madam Speaker, it's kind of confusing, and honestly, that didn't jump out at me until you asked it. When you asked it, then I thought, yeah, that is a possibility.
All right, thank you. Is there anyone else who'd like to testify on 245 or 257? If not, Senator Kanata, any other questions on those bills?
Just the ones I previously stated, Madam Speaker, that's all I was a little bit concerned about on 245. That's it.
Thank you, Senator. All right, again, I'm welcoming additional testimony for the next 5 days. If you could get it in to Senator Terlaje@gmail.com. Otherwise, we will consider the hearings on Bill 245, 246, and 247 duly heard. It is now 4:25 p.m. Sizos Masi to all of you. Thank you.